For this video lecture, we're going to briefly look at the non-legislative powers of Congress. Obviously, as the legislative branch, the bulk of Congress's powers involve passing legislation, passing laws. And we'll look in class in depth at the lawmaking process as well as the topics that Congress can actually pass laws about in Article 1, Section 8 of the Constitution. But there are some notable and important non-legislative, non-lawmaking powers of Congress that are going to be significant throughout the remainder of the course of this class in order to understand the way our various branches of government interact. A few of these are review. So from the fall, quick review, remember that Congress is the branch of the federal government that's involved in the constitutional amendment process. To amend the U.S. Constitution, it requires both the federal and state governments. Remember that the amendment process is probably the single best illustration of how federalism works, of shared sovereignty between federal and state government. And to amend the Constitution, as you'll remember from the fall, all you have to be able to do is count to 5. You need one member of Congress with an idea. That individual can be in either the Senate or in the House, or it could be a member of the Senate and House working together, as you can see in the screenshot that I've included on the slide of a proposed constitutional amendment from Senator Cruz, as well as Representative Rooney. So a member of the Senate and House working in context with each other, introducing the amendment in both chambers. The reason that's necessary is in order for a constitutional amendment to be proposed, which is the first step of the amendment process, you need 2/3 approval, 2/3 vote by both the House and the Senate, both chambers of Congress. So again, counting to 5, one member of Congress with an idea then must be proposed formally by a 2/3 vote in both the House and the Senate. If the amendment, so in the case of this term limit amendment proposed by Senators Cruz and Representative Rooney, if 2/3 of the House and Senate vote yes on this proposed amendment, it would then be forwarded to the state legislatures to be ratified, at which point you would need 3/4 of the states to vote yes, 3/4 of the state legislatures to vote yes to ratify the amendment, at which point the amendment is added to the Constitution and it is fully part of the Constitution, the same as something that was ratified in 1789. So again, counting to 5, one member of Congress with an idea, proposal by 2/3 vote in both chambers, ratification by 3/4 of the state legislatures, and then the 5 is Article 5 of the Constitution lays out the amendment process. Notably for this unit, remember that only Congress has a role in the constitutional amendment process. The federal courts have no role in the amendment process. The president has no role in the amendment process. He can't propose an amendment. He can't veto an amendment. This is solely a power of Congress at the federal level, and then it requires ratification by the states. Also, as a review, remember Congress does have election roles in the presidential election, potentially. As you'll remember from the fall, it requires 270 electoral votes to be elected president, which is a majority of the Electoral College. But remember that the math could play out to where no one receives a majority of the electoral votes, either because 2 candidates split the Electoral College 269 to 269, or if a third-party candidate could actually win electoral votes, which they haven't done since the 1960s, that would increase your odds that no one gets to 270 electoral votes. In the instance where no one receives a majority of the electoral votes, the presidential election is then decided in Congress. That has happened twice in U.S. history, once in 1800 and then again in 1824, which is the map that you have on the screen. As you can see in that election, there were 4 candidates. And in the electoral vote, Andrew Jackson received a plurality of the electoral votes, 38%, 99 electoral votes. But obviously, that's not 51%. And the presidential election requires a majority of the electoral votes. So the Jackson, Adams, Crawford, Clay election went to the House of Representatives. The president, in the event no one reaches 270 electoral votes, the president is selected by a vote of the United States House of Representatives, where each state receives 1 vote. So in 1824, members of the House voted as state delegations. Like in South Carolina, we have 7 representatives in the House currently. They would vote as a collective whole, and there would be 1 vote from South Carolina. You need a majority of the states. So you would need 26 out of 50 states in the House to be elected president. The Senate elects the vice president in the event that no one gets to 270 electoral votes. In the Senate, each senator gets one vote. So it's not by state, it's by senator. So remember, the House picks the president in the event that no one gets to 270 electoral votes. The Senate picks the vice president. Those are the two review things. The new things, first off, is senatorial advice and consent. Article 2 of the Constitution lays out the powers of the presidency. And many of those powers have the caveat that the president can exercise the power with the, quote, advice and consent of the United States Senate. So the president has multiple powers that he or she can enact with the advice and consent of the Senate. And the Constitution is not clear on what advice and consent means exactly. And so the development, kind of an informal development in our system of government, is that George Washington, the first president, interpreted that to mean that for Washington to enact those Article 2 powers that require advice and consent, he needed to obtain majority approval from the U.S. Senate, in effect, a majority vote approving, consenting to the president's action. And that's become the standard for constitutional advice and consent of the U.S. Senate for presidential actions. There are two types of presidential actions in particular that require Senate advice and consent. The first is any presidential appointment to a position. The chart on the screen shows the Senate vote for the confirmation of Supreme Court Justice Brett Kavanaugh, a Donald Trump appointee. As you can see in the breakdown, Justice Kavanaugh received 51 votes yes in the U.S. Senate and 49 votes against him. That satisfies the constitutional requirement for advice and consent for a presidential appointment. It only requires a majority vote in the Senate. So in Kavanaugh's case, he got 51 out of 100. He is confirmed to the U.S. Supreme Court at that point. He's appointed by the president, then confirmed by advice and consent of a majority of the Senate. That's true for all major presidential appointments, in particular notable for our course federal judges at all levels, Supreme Court and below, and key executive officials like cabinet secretaries. So another example, the chart that now shows up on the screen is the Senate tally of votes for the confirmation of Betsy DeVos as U.S. Secretary of Education. DeVos was a Trump appointee. In the case of DeVos, you can see it actually got kind of interesting, and this is a good reminder on a power of the vice president. DeVos was a 50-50 split. 50 senators voted to confirm her, 50 senators voted against her. So in that instance, anytime the Senate ties 50-50 on any vote, the Vice President of the United States then votes as the tiebreaker. And so in the case of DeVos, Vice President Pence broke the tie and voted yes on DeVos, which made her confirmed she received advice and consent of the Senate. If DeVos, Kavanaugh, any presidential appointee fails to secure a majority advice and consent vote from the Senate, then the president is required to appoint a new individual to that role because the Senate has rejected the president's appointment. The other big vote or presidential action that requires Senate advice and consent, just showed up on the screen, is treaty ratification. Article 2 of the Constitution says that the president alone has the authority to negotiate treaties with foreign nations, but whatever treaty is negotiated by the president before it can be enacted and have the force of law in the United States, and in effect for the president or the United States to be a full signatory to the treaty, it must receive the advice and consent, the ratification of 2/3 of the U.S. Senate. So please make note of that. Advice and consent on appointments requires a majority of the Senate. Advice and consent on treaty ratification requires 2/3 of the United States Senate. And if 2/3 of the Senate does not vote yes, then the treaty is rejected by the United States. Even if the president has negotiated and signed the treaty, it is not legally binding in the United States until it has been ratified by 2/3 of the U.S. Senate. The final non-legislative power of note of Congress is the power of impeachment. And the Constitution lays out that the Congress has the authority to impeach members of both of the other two branches. You are probably most familiar with the power of Congress to impeach the president, which also encompasses the vice president. Now, they are two separate entities. The president can be impeached and not the vice president or vice versa. but the impeachment power extends to both of those offices. And the impeachment power extends to federal judges. They also can be impeached by the U.S. Congress. So Congress can impeach either the leadership of either of the other two branches. To be impeached, it's a multi-step process. First off, you can't just be impeached for anything. There are specific constitutional grounds for impeachment, specifically for the president, less so for the courts. The grounds for presidential impeachment are at the bottom of the screen. That's Article 2, Section 4 of the Constitution. And as you see, the president can be impeached for treason, bribery, or high crimes and misdemeanors. Those are the only three categories for which the Constitution allows impeachment of the president. You will notice there that there's nothing about job performance. There's nothing about ineptitude. There's nothing about unpopularity. Those are not impeachable offenses under the Constitution. The president must have committed treason, bribery, or high crimes and misdemeanors. Now, and those same criteria, obviously, as you can see, apply to the vice president as well. Obviously, of those three, there's a big gray area in the third one, high crimes and misdemeanors. What does that mean? Because treason and bribery, those are pretty straightforward. There's a legal definition for both treason and bribery. But high crimes and misdemeanors is more subjective. And the answer to the question of what does high crimes and misdemeanors mean is it's whatever 51% of the House of Representatives thinks it is. So the House of Representatives impeaches the President of the United States or impeaches a federal judge. And just as a quick side note, the grounds for impeachment for a federal judge is, quote, bad behavior. We'll talk about that more when we get to the federal courts 3 units from now. But I want to focus on presidential impeachment for the moment because that's the more prevalent and more likely to be asked by the AP exam. So treason, bribery, high crimes, or misdemeanors. The House of Representatives brings charges against the president on any of those grounds. Impeachment, to be impeached by the House, means to have charges brought against you. Here's how I want you to think of impeachment. In our judicial process, if you are going to be charged with a major crime, a felony, there's a 2-step process. You first have to be indicted by a grand jury, and then you have to be convicted by a trial jury. Indictment means that there is enough evidence against you. A grand jury feels there's enough evidence against you to put you on trial. Indictment's almost a pre-trial motion. So, for example, if I go out and I steal a car today, and I get arrested by the cops, before the cops can put me on trial before the prosecutor, the local attorney, can put me on trial for grand theft auto, the prosecutor must bring evidence before a grand jury, a civilian group that has been called for jury duty. The prosecutor will introduce the evidence that they have against me. And then if the grand jury feels there's enough evidence to put me on trial, they will indict me for that crime. It doesn't mean I'm guilty of anything. It doesn't mean I even go to jail. It just means I can proceed to trial. The House of Representatives in the impeachment process works the same way. If a majority of the House feels that there is sufficient evidence that the president has committed treason, bribery, or high crimes and misdemeanors, then they can impeach the president and bring charges against the president, which puts the president on trial. So on the screen, you have the impeachment articles that were introduced against Bill Clinton in the 1990s. The House brought forward 4 charges against Bill Clinton. You can see them: perjury before a grand jury, perjury in the Paula Jones case, obstruction of justice, and abuse of power. Now, obviously, none of those are treason or bribery. But the House felt that, or at least the House Judiciary Committee felt that those 4 were, quote, high crimes and misdemeanors. And as you can see in the vote tally, a majority of the House found that there was sufficient evidence against Clinton to put him on trial for perjury before a grand jury and obstruction of justice. Clinton was impeached on those 2 issues. You see a majority of the House did not find enough evidence to impeach Clinton on perjury in the Paula Jones case or abuse of power. So those 2 articles of impeachment did not proceed against Clinton. And in fact, those 2 charges. So think of those charges as multiple crimes like grand theft auto and fleeing across state lines with stolen property. Like, you could put multiple charges there. So the House, a majority of the House, found that Clinton, there was enough evidence to impeach him for those 2 charges and to put him on trial. So impeachment means to put a president or put a political official on trial, at which point they will have a trial. Impeachment, however, does not mean removal from office. When a majority of the House impeached Clinton for perjury before a grand jury and obstruction of justice, Clinton remained president with all the powers of the presidency. He simply was put on trial. Removal of the president, the trial of the president, then happens before the Senate. So if a majority of the House finds sufficient grounds to impeach a president, the president then has a trial before the U.S. Senate. And the trial works just like any other judicial trial that you've seen on Law and Order. If you went to the National Advocacy Center, the trial you participated in is a good example. It's a trial with a jury, with judges, with attorneys, with evidence, with witnesses. The only difference is for the president in an impeachment trial, the U.S. Senate is the jury. Instead of a jury of 12 people, you have a jury of 100 senators. And instead of just any old judge, the judge is the Chief Justice of the United States. So this is the impeachment trial of Bill Clinton. And so you can see here are your 100 U.S. senators. They are the jury. Up here is, at the time, Chief Justice William Rehnquist, the Chief Justice of the U.S. Supreme Court. He's the judge. And here are the prosecutors, which are members of the House that have brought charges against Clinton. And here's Clinton's defense team, his attorneys. And during this trial, both sides brought forward witnesses and questioned them and introduced evidence. And it worked just like pretty close to like a normal trial. At the end of that trial, the Senate was required to vote on removal of the president, and it requires a 2/3 vote in the U.S. Senate to remove an impeached president. If 2/3 of the Senate votes to remove the president is no longer president of the United States. They lose all powers associated with the presidency, and the vice president becomes the president. That has never happened in U.S. history. We've had two presidents that have been impeached. Andrew Johnson in the 1860s was impeached by the House, and Bill Clinton in the 1990s was impeached by the House. Both of those individuals were put on trial before the Senate, but in both cases, the Senate failed to reach the 2/3 vote threshold, which meant that both Presidents Johnson and Clinton remained president, and they served out the remainder of their term. Now, you're probably thinking, wait, isn't there one president who's been impeached and removed? Nixon. And the answer is no, because Nixon actually resigned from office before the House could vote on articles of impeachment against him. Articles of impeachment had been introduced against Nixon, and he stepped down from office before the House could vote on impeachment, which obviously means it was well before the Senate could vote on removal. Nixon is the only president in U.S. history to resign from office. So you have two impeached presidents, Johnson and Clinton, but neither were removed, and you have Nixon who resigned.